Today we will be looking at the area of criminal law in the United Kingdom and the different actors in the criminal process. First, we will take a look at the police. The primary function of the police is to investigate alleged offences. During their investigations, police in the UK are not under the control of a judge or prosecutor. However, they may seek advice from the prosecution at the investigative stage, especially in serious or complex cases, usually on questions involving the admissibility or sufficiency of evidence. Thus, there is a clear separation between the process of investigation and prosecution. The police also have a duty to press charges against the alleged offender. Once the accused is charged, then and only then is the case passed on to the Crown Prosecution Service, also referred to as the CPS. The CPS was set up in 1986 to prosecute cases investigated by the police. Although the Crown Prosecution Service works closely with the police, it is independent of them. Prior to 1986, the investigation and the decision to prosecute had come within the responsibility of the police. This, it was felt, led to abuse, linked to police emphasis on getting a result rather than finding the guilty party. The independent character of the relationship between the investigative police and prosecution services was introduced by the Public Order Act in 1985. However, a private individual retains the right to institute criminal proceedings in the UK. This enables the individual to take action in the event of a refusal to prosecute by the CPS. The most famous example of a private prosecution in recent years concerned the case of Stephen Lawrence, the victim of a racist murder. The CPS considered that there was not sufficient evidence to prosecute the main suspects for murder, and this caused a public outcry. The family of Mr. Lawrence, as a result, instituted a private prosecution, which unfortunately failed. Years after the inquiry, two of the main suspects were finally successfully prosecuted for murder. However, not for the first time, the UK police came out of the process tainted with corruption and inefficiency. Now let's look at the issue of bail. There are, in fact, two types of bail. First, police bail. Once the accused is brought to the police station, a police officer is appointed as custody officer. The custody officer is independent of the investigation and keeps a record of the suspect's movements, the time and duration of interviews, for example. Once a person has been charged with an offence by the police, the custody officer must then decide whether to keep that person in custody until his court appearance, or alternatively to grant him bail. The second type of bail is called bail on adjournment. When the defendant appears before the magistrate's court, the court may adjourn the case for hearing at a future date. At this point, the court will have to decide what to do with the defendant. It can either grant the accused bail or alternatively remand him in custody. If the police or the court decides to grant bail, it may make it conditional, for example, requiring the accused to provide a surety, whereby another individual guarantees to pay a certain sum of money to the court if the accused absconds and fails to attend the subsequent hearing. Alternatively, the accused may be required to report to the police every couple of days. In common law countries, bail is a right, and so any refusal of bail must be justified. Legitimate grounds for refusing bail have to be based on the police or the court having a reasonable belief, rather than just an apprehension, that the detainee will violate his or her bail conditions. The grounds for justifying the refusal of bail are that the accused will abscond, will commit further offences whilst on bail, will intimidate witnesses, will be the victim of reprisals, or if the accused is homeless, having no fixed address. Now finally, let's look at the issue of legal aid in the United Kingdom. When in detention, the accused has an automatic right to a lawyer. Once charged with an offence, it is necessary for the accused to apply to the court for legal aid. Legal aid must be granted by the court where it is necessary to do so in the interests of justice, and the defendant's disposable income and/or disposable capital are such that he requires assistance in meeting the costs which he may incur during his trial. The legal aid lawyer assists the accused before and during questioning, and also in the case of an identification parade, also referred to as a lineup, if such a parade is held. Also, the lawyer represents the accused at any subsequent trial. We hope you enjoyed this introduction to criminal procedure in the common law, and in particular in the United Kingdom.